Domestic Relations Task Force. The time is 10:03. Everybody's time is very valuable. I'd like to go ahead and get started. We have quite a few folks understandably joining us via Zoom, so I'm we'll be addressing y'all primarily, even though you can see some of the other members of the task force here in the room. I want to make sure that any and every person that is joining us via Zoom, to make sure they are comfortable speaking up at any point in time as if you were here in the room with us. And I really appreciate y'all taking the time out of your schedules to join us for this. As I stated in my email, well, I didn't state this, but I signed up to be a chancery judge in Rankin County, not to be a chairperson of a legislative task force. So I'm kind of winging it as we go through this. I figured that y'all's time was just as valuable as mine. And so I wanted to make clear in the email that I'm not expecting to keep us longer than we need to be, and certainly not beyond noon. So I'd like to go ahead and get started. And if anybody has...
You're sounding very much like a legislator. So whether you signed up for it or not, you're doing an excellent job.
Does that mean I can fundraise for every year instead of just election years?
Okay.
So I emailed probably late yesterday a draft agenda of what I wanted to do. Listen, this is one of the things that I'd like to go ahead and just finish, because from the tenor of what we saw at our last legislative task force meeting, and from what I have heard from those individuals I have been able to personally contact and talk with on the phone outside of the meeting, I think that I haven't heard anybody that is not in line with making some sort of amendment to the divorce statutes. That was one of the matters specifically provided for in Senate Bill 2621. I'd like to go ahead and see if we can't finish our work on that aspect first thing this morning, so that we can move on to other matters that were in that Senate bill as well, because there were a lot. And we had quite a discussion about the issue last time, and I'm going to really be leaning on Senator Wiggins for this, but we know that the bill asks... Oh, yeah. Thanks, Mark. Thank you, Mr. Chin. Sounds like a motion to approve the minutes from the last meeting before I dive into the substance of the task force agenda. And I really appreciate Mr. Chin raising that issue. Shortly after Secretary and Judge McCarty finalized the draft of the minutes, I emailed those out to everybody, hopefully, on the task force, requesting that y'all have take the time to review them to make sure that they are accurate. There were certain individuals specifically named in the minutes, and if anything is ascribed to them, I want to make sure that y'all have the opportunity to review it to make sure that it was accurate. I re-emailed those out again yesterday afternoon. Does anybody have any questions about the substance of those minutes that Judge McCarty drafted up when we sent out? Anybody in here? All right. Mr. Chen has moved that the minutes be approved.
Second.
With a second from Senator Wiggins. Any discussion? Hearing none. Anyone opposed? All in favor of approving the minutes, Raise your hand if you're on Zoom
Aye.
and say aye if you're here. Very good. Anyone opposed? If you're opposed, this is the time to raise your hand. Very good. Minutes will be approved. I think there's a signature line for myself and Judge McCarty on there. We'll go ahead and get those finalized and to the appropriate party. Moving on to the next matter. I would love to finalize this, whatever recommendation it is that we're going to make on the no fault, what I call the less fault issue before the task force. Senator Wiggins reminded us, and Representative Cockerham reminded us last time that our job is not to draft the legislation, but rather to make recommendations. So I'd love to finalize what our recommendation is going to be. Because in my opinion, since that seems to be such there seems to be such a consensus about it, as powerful of language that we can possibly provide in our recommendation, I would like to see to make sure that whoever reads this, the legislators, can fully understand what this task force made up of experts or people that are at least highly involved in domestic relations and divorces, what they recommend. So what should our recommendation look like is the question on the floor. I don't think that it's any secret that, you know, as far as I was concerned, we needed to have something palatable for the legislature to be able to pass. So we looked at less fault grounds like the irretrievably broken, the complete incompatibility grounds, the removing willful or obstinate from the desertion ground. We also looked at something akin to what states like Wyoming have, and that is a, you know, one ground for divorce, and that is if either party desires it. If there is either party states that there's irreconcilable differences, they're entitled to it. That was more of a true no fault ground. So I'd love to know what kind of recommendation that we can place, that we can sign and present to the legislature. I appreciate the emails that I've been getting from task force members, including all of whom I respect very much. Is there any discussion about that?
Mr. Chairman, may I?
Yes.
Just as a guidance, or at least to weigh in on that, yes, we said we don't need to draft the bill. But like you're indicating last time we talked about, there's these different versions, if you will. What we at least found out, at least what I took away, was there's what is considered no fault differs from state to state. And so I think you hit on it, is when we make provided we make the recommendation, kind of what it looked like, irretrievably broken or something like that, rather than just saying we need a no fault provision. Because I think for Chairwoman Cockerham and myself, you know, we need to be able to narrow that down. And I'm just throwing this out there. For example, the Alabama has always been very, I guess, well accepted. It's certainly down by my area. And I think if I recall right, it had the irretrievably broken language in there. So all I'm suggesting is whatever the recommendation is, says we need a no fault similar to Alabama, the way they do it. It doesn't have to be, here's the whole bill, but we think this issue is, you know, within that bounds. Does that make sense, what I'm trying to say?
Yes, it does. And you know, and I don't like using, I think Professor Bell will be proud of me. I don't like using the term no fault, because that's not exactly what we're talking about at all.
And I will actually say, I learned that that's been the connotation within the legislative body. And what I realized last time is that that's actually a misnomer, so to speak. So I think that, and that actually, I think for Angela and I, that will help, because we can actually say, look, this is what no fault truly means, or this is what it is legally.
I had opened it up for discussion. Does anybody want to jump in there on this?
I have more of a question for the legislators. And maybe for the group, is there room for, and is commentary useful? So in other words, if the report said we recommend a form of no-fault divorce similar to that in Alabama based on irretrievable breakdown of the marriage, is it helpful to have in the report commentary that the commission envisions, the task force envisions this as allowing a judge to grant divorce if the judge believes, based on the evidence, that the differences between the parties can't be mended? Or is that not helpful?
Along those lines, from what she's saying, I'm wondering too that if we don't start out with where we see that the overall problems with our current statute are, and what our goals then, like the exact problems we want to solve. And like she's saying, I mean, what are our goals? Maybe our goals are to support marriage and family. Our goals are to give litigants better access and easier access to the relief that they're seeking, things like that. The positive goals that we have, the problems that we see, the positive goals that we have, and then like Professor Bell says, so that a judge may more easily address these domestic problems.
And on top of what the judge says, do we need anecdotal evidence, like some of the stories that Mr. Chin told the other day, that all of us who practiced or are sitting on the bench have experienced?
I think all of those are good questions. With respect to the commentary, I think that it could be helpful, especially if we're going to make reference to a particular statute, for instance, the Alabama. I think it would be particularly helpful when we start debating or we start taking up bills, or even helpful to the legislative staff, the legal staff, when they're drafting particular legislation. We get a lot of questions on the floor or even in committee, as you can imagine, both Bryce and I, with respect to members or colleagues who have questions about, or who are going to have questions after the task force finishes meeting. So I think the commentary could be helpful, whether it's going to be in committee or on the floor, for those members who may not even be privy or have an opportunity to come back and look at these particular hearings, and they'll actually be able to cite or look at the reference from the commentary to see how we wound up at a particular point. So my suggestion would be, yes, where it's needed and we think that it would be helpful to have the commentary.
But I would add to that, and I'm going to speak more of a logistically procedural issue. I think having the recommendation, and then yes, those things matter, but we don't need to spend, and I'm going from previous task force that have been on, to spend hours detailing all that to write down or whatever. What I envision, because this has been done in other matters and task force, is that you have the recommendations, and yes, have the supporting and all this information that has been provided. We will collate that and put that together so that Angela and I will have to give to our colleagues. And then particularly when the legislative session starts, and I'm speaking for myself, that provided this task force comes with recommendations, let's just say they do, then this information will be called up and presented to the committee, and maybe even have Judge Odom come testify before the committee to give us the background, and all this information that has before us would be presented to the committee. Talk to Angela. We may even do a joint House and Senate Judiciary A meeting with that. So I guess what I'm trying to say is, yes, it's relevant. I don't think that we need to spend an hour and a half going through all of that. If there's the recommendation like Judge Odom's saying, and just a framework, and then the information that has been given already, and then we can use that in paper form, if you will, to give to the committees. Because the reality is that if this moves forward, the committee will vote the bill out, and then we will present it on the floor, which that's what Angela's saying is we'll get questions. And by having this information before us, we can answer those questions to our membership.
Thanks.
Questions like, can you explain more?
Judge, I think your point about are we supporting marriage and all that, because certainly within the legislature, there's been the debate about if you support no fault divorce, you're not supporting marriage, which I think is not true. And I think with the information that we've gathered in this task force that would be information that we can present on the House and Senate floor. But understand that this is going to go through, this will be the task force, and it goes through the committee where questions will come up, and then it goes to the floor for each one. So that's how the fact that this task force is addressing this issue, and if that's the recommendation that comes before it or comes out of it, I think that's saying a lot to our colleagues in the legislature.
Mm-hmm. I mean, I can write one paragraph just to say how this would help parents, children, divorcing couples basically sustain their family and end the conflicts that they have between them, and support each other better and support their children better.
That's the second. I apologize.
Oh, no, go ahead.
Judge, I think that's your second sentence. The first sentence goes along the lines of, while honoring and respecting the institution of marriage, the recommendation is to modify grounds of divorce so that a judge may grant one in light of an irretrievably broken standard.
Yeah, this is what, I'll just throw it out on the table. This is what I envisioned would happen. That the task force would recommend something along the lines of what Senator Wiggins mentioned earlier, the irretrievably broken ground that would, I assume, replace the seventh ground we have being habitual, cruel, and inhuman treatment. I don't know if there's any need for it. This would replace it. That would be the recommendation of the task force. And like Judge Schlogel said, we would include a paragraph or two about why, from the judge's perspectives, professors' perspectives, practitioners' perspectives, why this would benefit families. Ironically, as it may sound, would be in the better interest of the children. Oftentimes, just give a short explanation of why we feel that it would be helpful to have a less strict standard for the chancellors to consider in these divorce proceedings.
We're on the same page. I was thinking the same thing. That was what I had in mind in terms of the commentary. In other words, the recommendation and then one or two paragraphs just expounding on that.
Yes,
And
and how the litigation itself is what is so destructive to families that need to stay intact even after divorce.
What we can do is Judge McCarty can get started on drafting the language of our recommendation. We are going to make sure that we get input from every single person that desires to give input I would love to get my hands on, I'm going to get with Judge Slogel and really hammer out from the Chantry judge's perspective. Our belief.
This is Shirley Kennedy. Can I ask a question?
Yes.
Last time we met, there was some discussion about whether or not we should add any language about the parties having to live separate and apart for a period of time, such as many other states have in their statutes. Is that something that we want to consider? Is that something anyone would like some commentary about if we're going to offer some commentary? Or is that something that we don't really need to address at this time?
I can respond just a little bit. I have been thinking about that issue, and I'm wondering, I want to be careful with it. And this is why I'm saying this, because a lot of times when the litigation starts, they may not be separated at all. And sometimes people can't afford right away to find another place to live, and that's problematic. There's a lot of times problems with that at the beginning. So I don't want to force people necessarily apart with this, or to physically separate. But I do think maybe there does need to be some acknowledgement if they are separated already, how that plays into it. So that's all I have to say about that.
The option that was available to the option that we were discussing was taking out the requirement of abstinence from desertion. Y'all are familiar with Mississippi's current divorce statutes that provide for willful, obstinate desertion for the span of up to 1 year, which requires the non-abandoning spouse to testify under oath that she would have taken this person back had they come. Sometimes that is, sometimes that can be difficult to do under oath.
Judge Odom.
We were talking about just taking out the willful and the obstinate aspect of it and putting it more in lines with what Louisiana and other states had with the 1 year separation. And what were you about to say, Ms. Smith?
I had envisioned that we were going to do a statute that addresses just the so-called no fault, that either it's irretrievable breakdown and complete incompatibility of temperament, and not realize that you were contemplating amending or replacing habitual cruel and inhuman treatment, which I applaud. Not sure that would get past the legislature, and they've been very protective of that, as well as of adultery, which is the reason I think it needs to be standalone.
Yeah, I agree with you. And they just amended it just the other year to add the spousal abuse. I don't know if they're going to want to tinker with it again. I'm just trying to think. In reality, I don't see that habitual cruel and inhuman treatment would even come into play if we have an irretrievably broken standard. But that's a good point. We want to make it as palatable as possible, but also practical.
Judge, I think Donna's right on that. That makes sense to me, because we may have situations. One of the things I think about, I didn't think a lot about until the past 3 years, but is how much law we have devoted to HCIT type divorces, the utility we've all been used to of practicing law, of judges knowing it. People are still going to plead it. The legislature, in my experience, the legislature can enact a law January 5. It's going to take the bench and the bar 5 to 10 years to catch up. And so, and I'm not saying that as a negative. I was that way. You have to learn new things, and it's going to be scary. People are going to know how to plead habitual cruel and inhuman treatment and be wary of pleading perhaps a different ground that may supplant, as you pointed out, Judge Odom, it may end up supplanting or consuming HCIT. But I think if we leave it in line, the body of law is still there. The precedent is still there. It can still be accessed by practitioners and lay people. And one of the things I really had my ears pinned back by was reading Dean Bell's article from a few years ago and looking at the numbers she had compiled about people who were coming to court pro se. Judge Slogel, I know you've talked about that. Judge Odom said things to me about that, about how many people are representing themselves in divorce. They're not going to know about a new ground perhaps, but they're going to be able to pick up on Google Scholar and Google different things about habitual cruel and inhuman. So I think Donna's right that perhaps it may be easier to leave what there is intact, Judge, like you were talking about, especially because they just changed a little bit of the access regarding domestic abuse, and then bring in another way of doing it.
Could I add a comment about the 1-year requirement? I was the person, I think, who brought that up last time, saying, do we want this as a backup alternative? And the more I think about it, the more nervous I am about it because of the impact on victims of domestic violence. Because you could see that somebody could separate and then get such pressure and be in such fear that they allow their spouse to come into the house and stay for 2 or 3 days. And then that's going to break the running of the year. I think it may work against the people who probably need access to divorce more than anybody else. So I'm less in favor of that as a backup than I think I was when I initially mentioned it.
Any other comments about that?
I
It
have a
goes
motion.
along, I was just going to say, it goes along the lines of, I think our overall concern is that the ability for certain litigants or parties to take advantage of different things in statutes and use them against the other side to sort of force them to do things, blackmail them into doing things. This sort of gainmanship, one-upmanship type of mentality that we have. I think that's what we've got to move away from.
Well, and I too share Professor Bell's concerns. I've thought a great deal since our last meeting about those individuals who may be victims of domestic violence and how hard and difficult they may find it to be able to get a divorce. And so I want to make sure that we're not adding a further impediment to that.
And I would just say, I wasn't bringing that up because I was in favor of it. I just wanted to see what everyone's position was on it. I also agree. And there's so many cases where people just, without the domestic abuse, just cannot afford to live separately and apart. So I agree with Professor Bell on all of that.
Mr. Chairman, I have a motion.
Let's hear it.
The motion is that we prepare a no fault recommendation, and that a committee of 2 or 3 who you deem appropriate to come up with that language for that recommendation after hearing this discussion, and then we circulate that before our next meeting and come to vote on that at our next meeting for a final recommendation.
Second.
All right. Hopefully everybody heard the motion, and we got a second from Judge McCarty. Any discussion on that? Any objection, Judge Schlogel and Professor Bell, to being sort of along with myself, the initial drafters of that prior to circulating to the committee as a whole?
Be happy to.
I would as well.
Thank y'all. All in favor of that motion?
Aye.
Raise your
Aye.
hand if you're on the Zoom. Any opposed?
No. I was slow, sorry.
Any opposed? Seeing none opposed, motion will pass. Thank you very much. Let's move on to the next matter. Thank you very much. Okay, so the next matter, and this was actually one of the first 2 matters contained in Senate Bill 2621. So I imagine that meant that it was that we were to spend to give it a hard look. It was the child support issue. I had emailed out to everybody previously that Dr. Venor of the Center for Policy Research, who had been on the ground floor with Arkansas's recent changes to its child supports, shouldn't say statutes, they do it by rule, similarly to how they do it in Alabama by court rule. But she was on the ground floor with them switching over to a shared income model, which is, as we talked about last time, the vast majority, or not the majority of states and other U.S. territories use as their way of calculating child support. Dr. Venor asked us was grateful enough to be able to donate her time for a meeting, a Zoom conference. Those that were interested were on the Zoom conference. I asked Mr. McCauley if he would provide a summary of that Zoom conference for everybody, since it discussed the reasons why Alabama was switching over to a shared income model, which were the federal guidelines that even Mississippi has to follow. Mr. McCauley, I see you there on the Zoom. How are you doing?
Doing okay. Should I share my screen at this point? I created a PowerPoint to run through.
Yeah, are you ready? Do you need a little bit of time?
No, I'm good.
I really
Just let me
appreciate
know if you can see the screen.
There we go.
everybody on Zoom see the screen.
Yes.
Mr. McCauley, the floor is yours.
Thank you. So I like to start off with a roadmap of kind of what she discussed. So y'all know where we're going. She talked extensively about the federal requirements for child support guidelines. I'd say that probably took up about 90% of our conversation. She presented on what they were, what some new requirements were, and how states were making decisions to phase in those new requirements. And then towards the end, when it started to open up for questions, Donna raised a great point about shared parenting time. So we had a conversation about that. I'll go over the summary of that. We asked Dr. Venor about our current model and about shared income model. So that's kind of what I'm going to try to summarize for you right now. So this is the federal guidelines that require, as a condition of approval of a state plan, the state must establish one set of child support guidelines that meet the requirements of this section. So why is this important? There's many things in life that generally comes down to money. The state must update its state plan with any federal changes. If the Office of Child Support Enforcement doesn't approve a state's plan, it can impact the agency's funding, child support funding, and CANA funding. So that's millions of dollars that we get from the federal government. We're funded for every dollar that the state puts in, the feds match too. And so it's an enormous amount of money. And our state plan is kind of a way to certify that we are following federal guidelines. And so how did we get here right now? In 2016, there was something called the Flexibility, Efficiency, and Modernization of Child Support Enforcement Programs, what we call the final rule. And there's a number of stated goals. They tick off a bunch of buzzwords about flexibility, effectiveness, efficiency, and there's some great ideas in this new rule, and we implemented a lot back in 2017. The issue is that a lot of the new requirements involve your state guidelines, and since those are reviewed on a 4-year cadence, even though these changes went into effect in early 2017, we're only really dealing with them now because now is the time of our new 4-year review of our child support guidelines. And so these are kind of the topics that she brought up. 3 of them are new. I'm going to go through these pretty quickly, but focus on the new ones and then these other ones that she brought up as well.
Mr. McCall, can I ask, I'm sorry, can I, just for by way of explanation, the state plan, does everybody understand what that means? I guess is not. So, Mr. McCauley, please correct me, but in order for the state to draw down federal TANF dollars and federal dollars, the state has to prepare a state plan, and thus the federal government requires certain things, and this is what he's talking about. So in order for, is that right, Mr. McCauley?
Yeah, that's exactly right.
Okay, so just wanted to make sure everybody was clear about that. Thank you.
Yeah, so a lot of this stuff isn't talking about the model that we use or the percentage. It's really just some guideline changes that need to be taken into effect for ordering us to continue to receive federal funding. So it's not quite as exciting as what model we use, but it's very critical to the agency that these changes are made with the next what we call our quadrennial review. The first one is low income adjustment. And so what I've tried to do with all these is give you the language of what's there. And then the next slide will talk about what the doctor provided as far as how states are kind of meeting the requirements. And so the first one is child support guidelines must include a low income adjustment that takes into consideration the basic subsistence needs of the non-custodial parent who has a limited ability to pay by incorporating a low income adjustment such as a self-support reserve or some other method. And so states deal with this a number of different ways. If they have a shared income model, it's almost kind of like baked into their guidelines as part of the charts they use. Some states, if an NCP is making below a certain amount, they will just issue a $0 order. I don't think that's a great idea. Other states, what they do is if he's making below a certain amount, they would institute what's called a minimum dollar order, and it could be as low as $50 or $100. We talked briefly about what Mississippi currently does. And so we currently require a finding of appropriateness when the NCP's adjusted gross income is less than 10,000 or more than 100,000. And we kind of talked about this for a bit. I don't think she quite understood what this statute does, but once she kind of understood, she said that this probably currently meets the federal guidelines because it is in a sense an adjustment for people making below $10,000 a year. And so we don't necessarily have to do anything because she thinks this meets the federal guidelines, but there are other strategies that state are implementing that we can consider.
And Mr. McCauley, let me ask this question. It was from my understanding of the speech that Mississippi meets the guidelines probably in the minimal amount necessary, but that the shared income model used by some other states more solidifies their compliance with those federal guidelines.
Yes, and so with the shared income model,
right now we're good.
Yes, in this particular area, there's some other ones that we need to implement. But as far as having a low income adjustment, our model meets the requirement. And so the next topic that was talked about was imputation of income. And so the child support guidelines must take into consideration specific circumstances of non-custodial parents. And then there's a laundry list of things that need to be considered. The doctor mentioned the underlying rationale behind this change is that more fact-finding equals more accurate orders, which equals more consistent payments for non-custodial parents. Most states are simply adopting the language as it is. Some of them include caps on minimum wage orders. So most of the time in Mississippi, chancellors are, when they impute income, they're doing it at 40 hours a week at minimum wage. What some states do is look at the average weekly hours worked. I think she mentioned that the reality for a lot of people who are working in this service sector industry, they don't have regular hours and they're not offered 40 hours a week. And so they're not often offered 40 hours a week and they have a difficult time finding a second job because their schedule is so inconsistent. But the reality is they're really only working, 34, 32 hours a week instead of 40. And some states will cap a minimum wage order, not at 40 hours, but at a lower rate. This next new one that's pretty big that I think I mentioned on the last call is treating incarceration as voluntary unemployment. So there's currently federal guidelines in place that the agency has adopted into our policy, but it's not part of our state statute. And so we're already doing a lot of this. We're submitting what we call stipulated agreements to lower or suspend NCP's child support, but not all chancellors are on board with it because it's not law. And so a lot of them are refusing to sign it. The rationale behind this is NCPs are much likely to pay once they get out of prison when they've accrued, tens of thousands of dollars in arrears. It just drives off the number of arrears that have accrued, and oftentimes drives NCPs into the underground economy because they get out, they can't make payments, so they get into things they shouldn't have to kind of make ends meet. The agency submitted legislation the past couple of years to suspend child support by operation of law when someone's incarcerated for more than 180 days. So that's one option. Another thing that states are doing are they are providing exceptions when the crime is against the child or CP or the person is jailed for non-payment of child support. This is something that needs to be done whenever you're reviewing your child support guidelines. It's considering the economic data on the cost of raising children. And I think that's something that we might be missing in this conversation with the room full of attorneys is, there's discussion on what model to use and whether we need to raise the percentage up if we were to keep percentage of income. But really, these models are really based on hard economic data of the cost of raising a child. And so, kind of my recommendation is if we were going to change models or adjust the amount, that we might want to bring in an expert to help us work through this economic data to set percentage at the correct amount. And so we've pulled some information from the state economists from Mississippi. The doctor recommended reviewing Pennsylvania as an example to kind of reverse engineer what they did. And she also recommended pulling some labor market information from the Mississippi Department of Labor. This one's kind of interesting, that's new. It's when you're reviewing your child support guidelines, you need to analyze case data. And so we pulled 100 cases, and based off of 100 random cases, of those 36 were default orders, which I know there's technically not default orders on Rule 81 matters. What default means here is that the NCP didn't come in and sign an agreed judgment, or he didn't appear in court. And so, 1/3 of the time, we're taking what I would call default orders. Deviation from guidelines, that's 16%. I think that's kind of high. I think that might be a coding error. And then the big one that kind of relates to imputation of income is we're imputing income on nearly 50% of the orders that the agency is entering. That's an incredibly high amount. And it just goes back to when you're imputing income, you want the most accurate information available, and not just in lieu of fact finding, just doing a minimum wage order. So in order to meet the federal guidelines, she suggested we look at the payment data between the cases based off of default or imputation to kind of look at if you're imputing income on an order, is he more or less likely to pay? Or if you're taking a default order, is he more or less likely to pay? That's something that the feds require you to kind of review when you're looking at your guidelines. And then the last one was to provide meaningful opportunity for public input. And she suggested looking at Nebraska, which they conducted public forums, and their legal aid society helped them set these up. And Tennessee did just surveys. She said to look at those if we wanted to model those. I sat in on a national conference, and there was a plenary discussion that just dealt with NCPs discussing impact child support has on their lives. And it was just kind of eye-opening to get that kind of perspective from the people that we're serving. And so that's kind of like the requirements that we went through. I know I'm kind of flying through this, but afterwards, Donna mentioned shared parenting time, which is something that a lot of states have. She mentioned that the math is much more complex when you're dealing with two households. She gave us a number of states to review, Colorado, Oregon, and I think particular Wisconsin's interesting because they're a percentage of income state. And so what they do is up to a certain amount of shared parenting time, they use percentage of shared income. Once the NCP starts getting the child more than 25% of the time, it almost switches over to shared income. So it's almost kind of like this interesting kind of hybrid percentage of income and shared income model, depending on how much time the children are sharing the parent. And then a question came up about whether or not we needed a custody order. And so my concern with this kind of model is that most of the cases that the agency touches, there's not an underlying custody order. And so do you go by what the parents are saying, how much time has been spent between the families, or do you need a custody order? And so she suggested a lot of cases require, a lot of states require a custody order to factor in some shared parenting time adjustments. And another question that kind of comes up is, what is the right threshold? This didn't come up in our conversations, but I've just read that oftentimes if you set a certain amount where shared parenting time kicks in, that often creates a cliff where non-custodial parents trying to get that level of shared parenting time just so to have a lower child support amount. So you just don't want to kind of create a situation where it causes more problems than solves because people are fighting over how much time they have the child to avoid child support or the amount of child support. And then lastly, or I think we have one more after this, but we asked her about Mississippi's current percentages. And the kind of caveat that she gave to this is that when she's reviewing child support guidelines, she's looking at an incredible amount of economic data to determine how much it costs to raise a child. And she hadn't done that for Mississippi. And so she's said, you know, gave that as a caveat saying that she's not aware of all the economic data, but basically just by back of the envelope calculation, she thought that the 14% was probably appropriate for the higher income people. And for the lower income people, she said that might not be appropriate. But since we have that adjustment for reasonableness when he makes less than $10,000 a year, it was probably okay. And so she said what is really needed is for that middle income, she would really need to do more analysis to know how appropriate our current percentages are. And then lastly, we asked her about shared income versus percentage of income. She was kind of hesitant to go into the details about this because a lot of work goes into looking at the underlying economic data of the state. The most she would really say is that she's done this for a lot of states, moved from percentage of income to shared income. And she says that the legislators have always seemed happy with the end result. She did say she wasn't sure if a lot of the caseworkers in the field would agree because there's a lot of extra work to get the income of both parents. And so I hope that I covered, I know I really blew through that of what was discussed. And if anybody remembers anything differently, feel free to chime in. Again, there was a lot of math discussed that I just really kind of glossed over and tried to hit the highlights. But I wasn't sure if there are any questions about what was discussed or about any of the particular federal requirements.
Does anybody have any? Go ahead. Anybody have any questions about Mr. McCauley's presentation, which was a summary of Dr. Venora's presentation?
Judge, I've got one. Michael, what do you think?
What do I think?
Yeah.
About the guidelines? I think that we should seriously talk about adopting some of the requirements because it impacts funding. Was your question more about the guidelines or the shared, or which model to use?
Which model?
Again, I'm open up. The agent's is gonna implement whatever this task force comes up with. I think I mentioned on the past meeting, the agency has a lot of concerns about the cost of switching from a.
Michael, I'm sorry to interrupt you. And you're
That's
not
what we call a non-answer.
You're not in a courtroom, but you're still a lawyer and I'm still a judge. What do you think, buddy? I mean, we're just visiting here and you've been doing this and you do it to a scale, Michael, candidly, far larger and far deeper than I'll ever be able to access. What do you think is the better route for Mississippians?
For Mississippi, I would suggest percentage of income and looking at the percentages. I think my personal opinion is when you switch models, my understanding is that oftentimes you end up at the same place. There's just a lot of extra work involved to get there. And the only time there's a difference between the models is when there's a substantial There's not parity between the parties. And like I mentioned before, we currently have under state statute, pull it up. You can overcome the presumption of the guidelines for a number of different reasons. One of them is the total available assets of the obligee, obligor, and the child. I take that to mean if there's a significant disparity between the parties, that the chancellor has the ability to take that into account when setting child support guidelines. And so it happens in so few cases. It doesn't make sense to me to switch models when it happens in so few cases, and we already have a law in the books that allows chancellors to account for that.
The problem with that, though, is that so many chancellors won't deviate from the guidelines for any reason. That's my major problem with it.
Is it
If I
that they
may.
won't, or they don't realize that they can?
They don't want to. I'm going to go with guidelines. I don't care. I've heard virtually that said almost verbatim, multiple times.
If I may, I am not an expert whatsoever in the shared income model. Mississippi utilizes the percentage of income. That's what I'm familiar with. But what I did was to try and help better explain to myself, and maybe this will help y'all understand the shared income model. I took a look at another state that uses a shared income model to make a determination of how to do the calculation and what the end effect would be. And so I used an example of a mother and father getting divorced. The father makes $150,000 a year. The mother makes $42,000 a year. The way that those other states do this is they come to an adjusted gross income that is unlike how Mississippi comes to adjusted gross income. The definitions are different. In these other states, the adjusted gross income is simply what the gross income is minus prior child support obligations and prior alimony obligations. In Mississippi, as we all know, we also deduct taxes, mandatory insurance, mandatory retirement, et cetera, et cetera. But what they do is they come up with a total family income. In my example that I give, the father produces 77% of that income. The mother produces 22% of the income. And then these states have complicated, or not complicated, but extensive tables like what Mr. McCauley was talking about earlier, based upon a lot of economic data to come up with what the costs are to raise a child based upon the gross monthly income of the family. And in my example, if you had a gross monthly income of $15,917, which is what you calculate from the father making $150,000 a year and the mother making $72,000 or $42,000 a year, the charts would say that the total child support obligation would be $1,880. These shared income models, unlike Mississippi, require you to already include the actual cost of daycare or after school care expenses. So using a average of $450 a month, you add that to the basic child support obligation of $1,880, and you come up with a child support obligation of $2,330. And then from there, it's simply a matter of using the percentages we talked about earlier to determine how much each parent would pay for child support. in the example I'm giving, let's say the mother who makes $42,000 a year was awarded custody of the children. The father was the non-custodial parent under a standard visitation type schedule. 77% of $2,330 would be $1,817. That's what the father's child support obligation would be every month using the shared income model. In Mississippi, using the percentage of income model under those same facts, the child support obligation is going to be almost identical. So like Mr. McCauley said, under that type of example, you're using a lot of work to get about the same result. Because in Mississippi, you use 20% of the adjusted gross income minus, the adjusted gross income minus all the taxes and everything. Plus, the chancellors are going to require, except in exceptional circumstances, that the non-custodial parent pay at least 1/2 of actual child care or after-school care expenses. So you're going to get to about the same result. Using this example, however, and let's say the mother ends up being the custodial parent and was a stay-at-home mother and did not work outside of the home, thus not generating any income, the non-custodial father would still pay $2,330 under the shared income model, whereas in Mississippi, it would still be around the $1,800 percentage. So that's really where you get a difference, is when the custodial parent generates no income per how you calculate income under the statutes. Otherwise, in most situations, it's probably going to be about the same.
I've also heard in instances where the custodial parent's a stay-at-home parent, the states are often imputing minimum wage like they would with the non-custodial parent. So I don't know what kind of difference that would make, but that's what I've heard some states are doing. So there's probably even more parity between the models.
I ran quite a few examples using different levels of income. I understand that, Mr. Chen, I was using the Madison County level of incomes in that last example. But I used it using minimum wage, and I used it with the custodial parent being the primary breadwinner. I mean, and in most cases, it came out amazingly similar as to what Mississippi was currently using for its percentage of income. But this is what I really got out of Dr. Venor's speech, and that is a lot of time and effort has to go into making a calculation as to what the child support obligations would be for your particular locale. And in Mississippi, it's going to be dramatically different, I imagine, than some of the other states like Pennsylvania that she was directing us to. So I don't know if child support is going to be something that this task force can truly, fully tackle and make a recommendation on, other than if we feel that we need to look at it further, we need to determine what steps we need to do in order to do that. Do we need to hire the services of a think tank to help dig into the economics of Mississippi to show us what that is, rather than just throwing it out there to the legislature? Go ahead.
Thank you, Mr. I have a couple questions. So, first, let me say, I'm speaking for me personally. Thank you, because what has just been discussed in the last 15 to 20 minutes has certainly educated me and is getting to some of the heart of why this was presented to this task force. So, Judge Odom, your analysis of the two is great. And I would say, as a legislator, there's no point in reinventing the wheel or doing a lot of work if you're going to end up with the same result. I totally understand. I get that. My question would be to Mr. Cawley, if that's the case, how come there's so many states that have gone through going to the model, the income shares, and doing all this work to end up at the same place? That's my first question. And then I have another question. Can you answer that?
Probably not really well, but in a lot of the discussions about shared income, there is a lot of talk about it seems more equitable or it seems more fair. And I think that a lot of times when states are moving from one model to another, that's kind of what's driving it. And I don't know how much weight you put on that. My understanding is that what happened in Arkansas was that there was a father's rights group that was really behind pushing the move from percentage of income to shared income model. So that's what happened in that one state. But there are some benefits to shared income model, but I just don't see the benefit for Mississippi.
Makes it, I'm speaking for myself. What you just said about what's driving the fairness, the income. I personally, as a legislator, hear that a lot. That the fathers are being, whatever reason, not treated fairly in this. And so I guess what Mr. McCauley's saying is that's what was driving the Arkansas change. I think there's value in the perception of fairness going on. That being said, I go back to what I said. There's no point. I mean, why do all this work if you're going to end up at the same result? That may be a perception versus reality type deal. And that in and of itself, from a legislator standpoint, may be part of the issue why we're getting this brought to us, is because within the system, if you will, there's this perception of unfairness against fathers in particular, but in general as well. But that leads me to the next point. And whoever brought that up about the chancellors, and we have chancellors on here. I tend to, based on what I've been told and gets to me as a legislator, but also in practicing, is I've heard there is no deviation from the statutes. Even though they can do it, it doesn't happen. And in talking to counsel over here, he was making a suggestion, well, maybe we can address it so that they will deviate to address it so there is fairness. The point being is that I think and I'm speaking again as chairman, but also as legislator, why this comes to us is because we are being told what is happening in different parts. Understand, in our position, it's not just from Jackson County or yes, it's from all over, is that these are the problems and they're not being addressed. Is that a chancellor issue, and why aren't chancellors more deviating from it instead of just going by the statute? So I present that because I think these are issues.
Oh yeah.
Okay.
I'd be more than happy to address that.
Yeah. Okay.
If I'm not mistaken, the Mississippi appellate courts have stated that if the adjusted gross income is above $50,000 or less than, what is it, Judge or Professor Bell, $5,000, you have to state specifically on the record why you are either deviating or not deviating.
Where's Justice Griffiths when we need him?
I thought that was
So
changed.
that's what I do. I don't know where Justice Barnes is or where Miss Barnes is practicing, but we make sure we follow the precedent set from the appellate courts and specifically state on the record findings of fact on why we are.
Can I ask Michael something about that? It's my understanding, Michael, that the first set of federal requirements requires us to do that our statute has to set a formula that chancellors can only deviate from based on statutory or rule factors, and that they have to be supported by findings of fact. So could we even change that without putting our funding at risk?
That's going to be my
Being
question.
change models?
No, aren't we required to have what Judge Odom just described as part of the federal requirements? That we have a statutory formula, and that judges can only deviate based on something that's listed in the statute.
Yeah, I mean, I can pull up what we have. There's a number of reasons
Right.
why we're able to deviate. Let's see if I can pull it up.
And I thought it was 100,000, not 50.
Right.
Am I
Yeah,
wrong?
it's switched within the past 5 years from 5 to 50 to 10 and
I
100,000.
didn't bring Professor Bell's book with me to look it up.
I brought it with me the first time. I'd like to echo something Judge Odom said from my viewpoint on the Court of Appeals, where we do, the majority of our work is domestic cases and felony cases. And so, which is what now Justice Griffiths did for 15 years before going to the Supreme Court. But, you know, and Donna, I hear you. It was hard for me as a lawyer to get a chance or to deviate. And Judge wouldn't say this because he's a real fair guy, but risk aversion plays a lot of this. I mean, what I would like to talk about what Judge Schlegel and Judge Odom do. I did not appreciate as a lawyer how difficult it is to do. Mark and I have talked about this before. The reams of data they're going through already to calculate a child support order. And so I sort of have the little bit of the solo left in me with Donna that goes out, why won't they deviate? I've given them a couple things and I'm begging them to, I'm showing them that he got a bonus last year of $25,000. But the tough thing is for a chancellor to step out on that plank when we've got 10 judges on the Court of Appeals and 9 justices on the Supreme Court who are very carefully reviewing these things. And I think it's tough to do. I think it's tough unless there's just a W-2 that says they're making $175 a year, which is pretty unusual. It's really hard for a chancellor to justify that and walk out on that deviation.
So what's the answer if there's, as we've discussed, a perception of unfairness? And what we heard is in Arkansas, that perception of unfairness of fathers drove the change to the income shares. But then what we're hearing is there is a deviation allowed, but then you're saying the deviation is they're not going to do it for the reasons you stated. So what's the answer?
I think I want to first go back to something I have not shook out of my head that Representative Cockerham brought up in our first meeting. And the thing I most often heard, Senator, when I was in solo practice, and now hear from lawyers who get my ear at different functions, is that we don't give enough to the custodial parent. And I really hear that a lot, is that the custodial parent, that 14% is not enough. And so while I think that we've seen, and I love that Mr. McCauley brought up and actually said fathers' rights groups in some states, that was what my research showed. You don't know who's drafting legislation or why it's implemented, but a lot of my research did show that because a lot of time it's the non-custodial parent stereotypically is going to be a man, especially in the South. It's going to be the higher income earner, which is just what our statistics show us is where we are in our society right now, that there was a push to try to lower it down. As Judge Odom pointed out, it didn't always do that. But that general overview we got the first time that y'all got for us showed in certain circumstances, especially lower income, we actually would see less money go into the pocket of the custodial parent. Mm-hmm. So I'll tell y'all, just me as a person, not as a judge or a lawyer, that worried me just because we already have a tough economic environment in Mississippi, and the idea that the custodial parent would get even less in certain circumstances. That did concern me, Senator, but it's the Donna's larger problem is why sometimes our judges don't do this. I think it's a tough job. I think they do the best thing they can with the data they have. But if anything, going to Judge Odom's point, do we need to maybe then, Judge, go ahead and say, or Chairperson Odom, do we need to go ahead and say changing this one system to another is maybe off the table, but we could look at whether the 14% is still adequate? And I don't know the answer to that at all.
And that's something that you're right, I alluded to in the first meeting was perhaps we should, if it's allowable, if it's something that we could possibly do, maybe look at increasing the percentages if we were going to stay with our current model. And I think while David is looking to your answer, and I think Professor Bell again raised another fantastic question, is if it's something we could do in modifying the statute to give our chancellors a little bit more freeway in terms of making those adjustments if they saw that they could in certain circumstances. And so I think David is looking for that answer now, but I think those are 2 possible solutions that we could look at.
I concur.
To get to Senator Wiggins's earlier question, it is real easy for me as a chancellor to compute child support based on a percentage of the income of the non-custodial. It is one of the easiest parts of my job. When it falls within the level of presumptively correct child support, okay, which the vast majority of cases do. So I would, along with Mr. McCauley, probably be the last one to say, let's look at advancing to a shared income model. As a legislator, I would probably be all over it, because I think not only does it have the perception of equality or equity, I think it is. I mean, it takes into account a lot of economic data and considerations of concerning child care, health costs, all of these things that are involved in raising children. And yes, it may come to be about the same at the end of the day as Mississippi's statute, but the fact that it
Yeah.
would seem more equitable in a lot more situations where you have a non-typical situation. For example, a custodial parent that is making a considerable amount of money. I just think that it would be something the legislators would want to look hard at.
Do you
And
come to
can
that?
I add to that?
I'm sorry.
Could I add to that, just what you're saying, Judge Odom? And Chancellor, I would like to see a little bit more, I guess, statutory or legislative guidance, because like what you're pointing out, the perception that we have going on. And what we all know, that the majority of people paying child support are men. So when, they feel that it is slanted against them. So if you're, here you are, the chancellor, and you're trying to deviate and take into account other stuff, which I'm getting of being biased against men. And because I'm a woman, I don't think Judge Persons are just biased or doing anything differently than I'm doing in my district. But somehow or another, if I get a, male complaint because I'm biased against men. Now I just have to deal with that, and I deal with that, but that's fine. But it would be a little better if we didn't. I like the discretion that we have, but on the other hand, it would be nice to say, look, this is what the law requires me to do, and I'm doing it because of that. And for it to be fair. Donna, we can't hear you.
You left us speechless, Judge.
Ms. Smith, were you about to say something?
If I could ever get the mute off, yes. The problem I perceive with the percentage model is that it doesn't take into account basic expenses, childcare, health insurance. As you guys know, I practice in this almost every day. Oftentimes those are used as cudgels and as leverage for negotiation. I'm not going to buy that insurance or keep that insurance if you don't let me lower the child support. So perhaps there's a meet in the middle spot where the statute says the chancellor shall adjust based on daycare, after school, healthcare costs, things of that nature. Maybe that helped the judges out and maybe prevent a lot of the costs that Michael is anticipating to the state.
Anyone else?
I'd just like to add, regardless of what we do as far as moving models or changing the percentage, I think what this task force can do is address some of the child support requirements that need to be addressed in our next quadrennial review. The agency will submit legislation regardless, but having the weight of this commission behind some of the changes I would suggest as far as how we impute income and treating incarceration as voluntary unemployment, it would be great if this commission or task force addressed those issues.
I would, if we're going to discuss that, I would like to make a comment about the incarceration. It's a strange thing to say, I think it goes against most people's intuition that you should excuse child support for somebody who has committed a crime and gone to prison. But the more I've read about it, and after doing a project with my students at a prison, I think we're allowing those arrearages to build up for incarcerated parents and then having them leave prison with that massive debt that can never be forgiven does more damage to their families and children than charging them with child support, that they cannot pay it for the most part. And once they get out, it's just an albatross that they can never get rid of. And I would be in favor of something that, as you mentioned, Michael, just suspends it automatically. I don't want to take too long, but this project we did in a prison in Holly Springs, that was one of the main things that these men who had voluntarily engaged in programs on how to improve their lives when they got out. It was one of their biggest concerns because they said, we'll never be able to pay it off and it can't be forgiven. It can't be bankrupted. And we don't know, this is facing us for the rest of our lives. So I would be in favor of having that suspended automatically.
Totally agree with the judge. All it does is drive them to work under the table and we can't find it. Child support still accrues.
I agree. I agree.
Can I make this suggestion? If Mississippi were to move to a shared income model, I think that move is beyond what this task force can do. Other than to say, we would recommend either hiring the services of a think tank or the Center for Policy Control to provide the economic data and to better educate our legislators who will be voting on that rather than just this task force on the efficacy of that. And we can move along to more specific points like what what Representative Cockerham brought up and what y'all are talking about now. Can we do that?
Yes.
Yes.
Right.
In fact, the bill says to recommendations. Again, we don't have to draft the legislation because that's these people's job and our legislator's job. But with the recommendations, yes.
Right. That way we can concentrate on more specific things like the incarceration. Any other thoughts on
The judge, I'm sorry. And I think it's certainly appropriate based on what I've heard that if the recommendation is just what we've said here, that the recommendation is it's probably equitable or to move to an income shares, but also the conclusion is it ain't going to, we're going to end up at the same result, but that there is certainly a perception of unfairness that exists out there. I mean, and it would address. I'm just dictating, but I think that in terms of recommendation achieves what the purpose of this task force was established and passed by the legislature.
Well, I'd like to get some clarity. Are we saying that we're recommending that it's moved to a shared income model?
No.
Okay.
That's
All right.
beyond us.
All right. That's what
So
first. And then-
Saying them that we,
And then
the
second-
legislature hire people to look into that, or is that what we're saying?
1 second, Judge. Representative Cockerham was.
And then my second, just a comment is that if you mentioned maybe a think tank, I do think that perhaps LBO, if we need some financial information, they would be helpful in this particular instance. Maybe the state economist, we could tap that resource as well. And I think legislatively, there are some other resources, definitely both legislative services and the House and Senate could be helpful also, in addition to whatever other think tanks that we'd like to look at.
We can recommend we ought to look at it further
Mhm.
through those resources. Yes, I think that would be wise to do that. Judge, I'm sorry, I cut you off.
She answered it.
Okay, so, okay. We will draft that recommendation up and submit it to everybody to look at as well. Back to the issue of incarceration. my understanding of the law as it is, incarceration does not automatically terminate the obligation to pay child support. The obligor or the child support payor, the non-custodial incarcerated parent, the burden is upon them to demonstrate inability to pay and lack of resources. I think some of the appellate court cases that I had seen were pointing to incarcerated individuals that actually had considerable assets in which they would be able to pay their child support obligation, even though they weren't generating monthly income through employment. And I'm sure that could be addressed by any kind of legislation. If somebody had I don't know, considerable assets built up prior to. But I don't have an issue either with an automatically suspending the child support obligation while incarcerated for the reasons stated above. Anybody believe differently or have a different opinion?
Judge Odom, if I may, we actually, and Mr. McCauley had requested that we introduce legislation this particular legislative session to address that. And you probably had some legislation in the Senate as well, I
Oh, we
think.
killed it.
No, I didn't think you killed it. I thought maybe you passed it on the Senate side, perhaps. I
can't
know,
remember.
I know we
Close.
did on the House side, and it did not make it over to the Senate. So if we need to reintroduce that, if it's the recommendation of the task force that we do that.
I would also add, and I think this is part of the reason why this is tracking with the legislature and honestly, the movement across states for reform of the criminal justice reform.
Right.
Because, for example, the state of Mississippi has now said the state has to give parolees an ID, because what we found was they weren't able to go to work, and we want them to go to work. And if you can't drive, you can't go to work. So it's the same sort of thing, and just what was said. And so I think that tracks that. And I think I'm not sure why that legislation didn't go forward. I can't remember, but I think it's in line with what is going on now.
Definitely.
Yeah.
Can the task force get a copy of the proposed legislation or the legislation that was introduced last year and perhaps make a recommendation on it? We can discuss it.
Yes, and I will get with Mr. McCauley and we'll go forward. And I'll get it to you, Judge Odom.
Great. And that may be something we can address and tie up in a ribbon next time we meet.
Okay.
Great. What other issues concerning child support we need to address? Anyone on Zoom?
Mr. Chairman, I'm sorry.
Hey,
But
Judge.
yes, sir. I do want to point out Carol Murphy, Research Council at the Judicial College is listening in today. She provided y'all the information. She did the research along with the help of one of our law students. That I know there's a lot there, but that's just one issue related to child support that I know Senator Parker was interested in. So for today, I can't imagine everyone having the time to digest it yet, but Carol did an exhaustive research in all 50 states to determine what those states are doing regarding children that reach the age of majority and are disabled. So I would just encourage everyone to look at that, because that's a separate issue than what we've been discussing, but it's something I know that this committee was interested in tackling a little bit. And I just wanted to point that out and to thank Carol Murphy for spending hours putting this together. And then finally, in your gracious email, Mr. Chairman, you had given us credit for the Mississippi Law Research Institute's research for the age of majority issue. That was actually done by the Mississippi Law Research Institute at Ole Miss. And Will Wilkins is the leader of that group, and Cotton Rutherford. actually did the research. It can be updated if it needs to be updated, but I just want to make that clarification.
Cotton still roaming around the law school doing research.
Cotton is the man. He is still there.
That's great.
That was incredibly helpful research. I
It was.
looked through what she did. I'm so happy to have that. Thanks, Carol.
It was intriguing to say the least. But do we need to address the age majority in the state of Mississippi as a preliminary to that matter?
It looks like the majority of states allow for child support for adult disabled children. Yeah, my only concern, and I think I raised it last time, was that in Mississippi, we don't. We have that Ravenstein case where a father had previously agreed to pay for by court order that he did not appeal, or was court ordered to do it and he didn't appeal it. But that the only concerns I have would be what ramifications would it have on entitlements or other state-sponsored or state-provided benefits? And I just don't know the answer to that question because I'm not an economist.
Oh, yeah.
Anyone have any thoughts on it?
Okay.
I share that concern, and I don't understand either the impact of benefits that Medicaid or other programs might pay for if there's an existing support order. Rick Courtney is a lawyer in Jackson who is the person I know who knows the most about that. He spoke at one of my seminars one time. I know that is something that judges would have to be careful about when they put an order into effect, whether or not that was going to affect the child's benefits. But it must be that states are finding a way to deal with that, since I think looks like about 3/4 of states do require it. And I wanted to add on to that the other concern that I would have, and I think we should look at doing some form of this. My other concern is, I think for a lot of particularly middle income people, the moment when their children leave home, disabled or not disabled, is when for the first time they ever have the opportunity to put aside money for retirement. And so I would be concerned that although people should be helping to support a disabled child who truly cannot support themselves, it might not necessarily be at the same level as support during minority. And I did notice that a couple of the states that were included in the research had specifically said that factors that a judge should take into account would include the ability for the payor to put aside money for retirement. It's complicated.
Thank you, Professor. I agree. I think it is a lot more complicated than maybe you think whenever you think of the benevolent aspects of requiring that for disabled adult children.
Oh, no.
The case law that I have seen on this issue, and it's been raised before in my court, has focused on the impact it would have on benefit, state and federal benefits, and also upon, gosh, I think I found a case that cited back to, England's laws about it being the obligation to support a child over the age of emancipation is one based on love, and not one that should be state forced or something along those lines. Is some of the language that I've seen. It's complicated, and the research is incredibly helpful. Thank you, Justice Pierce, for helping to corral that research for us.
Well, I tell you, Carol does a fantastic job, and Bill Charlton too. Carol did 100% of this work along with Anna Claire Mercer, one of our law students. So Carol deserves the credit, but we appreciate the opportunity to work together with the commission.
Do we need additional time to digest the research contained here. I'll be honest with you, Justice Pierce. I know that you sent that to me a while back. And I don't know that I sent it to the committee until yesterday. So we probably need additional time.
Well, it's not your fault. We have been well, let me rephrase. Carol has been working hard with Anna Claire. And she, as you can tell, when you look at all 50 states plus the District of Columbia, you're looking at statutes, you're looking at case law, and Carol breaks it down as to whether or not the state bases this support on whether it was developed through case law or statutory authority. And so that took a lot of time. So you just recently got it yourself. So don't be critical. But we just needed that amount of time to get it together. But Carol worked many hours to get that done. But thank you.
All right. Any objection to letting us get a little bit more time to digest the information that was provided for in that research and discussing it at a later meeting? I'm not hearing any, so that's good.
No.
Great. Also provided you research done by either the Mississippi Justice or the Judicial College or the Institute of Legal Research on the age of emancipation. Perhaps that is as simple of a task for this committee to review as the no-fault divorce. That research indicated that the vast majority of states have an age of majority of either 18 or 19. Mississippi was one of two, along with Puerto Rico, maybe a territory of Puerto Rico, a Commonwealth of Puerto Rico, to have age of 21. I've talked with quite a few Chancery Court judges. Some believe it ought to stay at 21. Some believe that 18 is the way to go. It would certainly reduce the amount of child support modification cases that we have. What do y'all think?
Mr. Chairman, I will chime in here for a moment to Senator Wiggins and Representative Cockerham, but specifically Senator Wiggins. Senator DeBar, as you probably remember, had a study committee that looked at the age of majority. And that was in 2018, I believe. They had a hearing, and I was at that hearing when the Mississippi Law Research Institute memorandum was presented. And I remember the testimony basically saying that states are different. Mississippi, I think, is one of two states that still has 21, but every state that was looked at had some type of exceptions that applied, whether it was 18, 19, or 21. But I don't know what material was gathered during that hearing. Senator DeBar's office may know that, but I just wanted to let y'all know and to remind particularly Senator Wiggins that you may have, I don't know if you were involved in that or not, but I know Senator Dennis DeBar was chairing that hearing.
I wasn't involved in that, but this past legislative session, the Senate brought it up, his bill up, and we did research. My recollection is it didn't pass the House, but anyway, we did some more research on that, Justice Pierce. And there were exceptions made within the bill that was put forward, but there has been, opposition in certain corners to it for, I think, the reasons that have been stated here. But what is clear by the research here, Mississippi's one of only two states to stay that way. So
It didn't, there was a bill put forth by the Senate, but we do have quite a few bills introduced in the House to do this very same measure. I will say from the members on Judd A, we passed a bill to lower the age of majority with respect to stocks and bonds this particular session. So the reason why we didn't pass your bill is because we wanted to take a look at this measure a little bit further.
the House killed it.
Well, you killed quite a few of our bills too. And we've talked about this.
I know,
so.
I'm kidding.
But We wanted to take a look at this a little bit more in depth, but there's quite a bit of support on the House side to lower the age.
What, I'm sorry,
know-
what was it y'all were wanting to look at?
We wanted to study this a little bit more.
Oh, okay,
Yeah.
okay.
It just occurred to me, Senator Wiggins, that since part of the concern about child support is fairness, I think from the payor's perspective, this seems to me one way that we could very clearly address that issue of fairness by removing the obligation for a payor to pay child support for a child who's out of high school and not going to college. It's never seemed fair to me that basic support continues past high school years. College support, yes, but not basic support.
Are y'all, and I'm curious, Judge Odom and Professor Bell, so just kind of a benchmark, if that was lowered from 21 to, let's say, 18, that automatically would cut off a number of claims for child support from 18 to 21, I would guess.
Right.
It would. And
That's-
modification actions, as Judge
And
pointed out.
modificate. That's what you're saying, Professor Bell?
Yes.
I think this may cause an increase in looking at or interest in requiring parents to pay for college expenses, though. I mean, you also,
It would.
what's the trade-off?
I think though, Judge, that may be clear. A lot of what I think we end up with, you and Dean Bell both talking about the modification actions. We end up with a lot of stuff we see at the Court of Appeals where it's unclear whether the non-custodial parent is going to pay for college or what they're going to pay. Are they going to pay for cheerleading in college and all these complex things that maybe if you knocked it down to 18, that has to be more clearly expressed perhaps. Because I feel like
I
when we
agree.
see modifications, it's that. Judge Schlegel, you think that?
I agree with that. I have a lot of cases where it's women and they're the custodial parents. They're suing over the college expenses, and it's a lot of money. I would say most chancellors do not agree with lowering the age of majority, lower than 21, not just for child support reasons, but for other reasons as well. So we have to think about that too. I mean, I don't know. I mean, we could maybe change some child support guidelines that have to do with this. Not so much, I don't know how to work it, but I do think college is a big issue.
Well,
I would
and
add to
also-
that Judge Primo did a blog post on this about 8 years ago that I can circulate, but it seemed to be that his primary concern was college education and what lowering the age of majority would do to that. Another point he made was there would be an increase in what he called divorce blackmail in order to get support for college education. But I wonder if we are going to go along the lines of a no-fault divorce, maybe that kind of mitigates some of that concern.
Gwinnetta and I were just talking as well. If we lowered it to 18, we would want some consideration for those students who are still in high school, because sometimes students maybe don't graduate until they're 19. And so we definitely would want to take that into consideration as well.
The agency's position on that would be to follow Alabama, which does a hard line at 19. There's just a lot of administrative costs every time a child turns 18 to determine whether or not they're still in school. It's a lot of, I don't want to say it's a lot of work, but it's very time consuming on the agency side to verify that. And Alabama kind of solved that by just setting a hard date at 19. And you can always emancipate them earlier by judicial order, but it's kind of setting a hard age of majority at 19.
Judge, I'm curious, what are the other concerns that most of the chancellors have? I don't understand where you guys are coming from in objecting to reducing the age of majority.
Go ahead, Judge.
I would say, of course, college is a big issue, but medical concerns most people are still supporting their children a lot of them through age 21, especially if they are in college. And so, I don't know. I guess we look at it like it gives parents a little more, ability to parent. You've got kids, I mean, when drugs and alcohol are a problem, I mean, there are all kinds of problems that college age kids are having.
What I'm seeing, particularly again with male clients, you were litigating because, or they're trying to litigate anyway, because the money is still going to mama and they don't understand that mama has to keep a roof over their head. They think she's just flittering away, buying jewelry and all the rest of that. Perhaps, lowering it, but providing for post-majority support in the form of college and healthcare, as Professor Bell suggested, might be a compromise there to accomplish something that appears to be more fair to men.
It's complicated. I had a case just last week where when the child was 5, the father entered into a child custody support agreement that he would pay $567 a month in child support till the child was 21, plus half of college expenses, including transportation, till the child through a master's degree. And he had brought that up for modification of that. And yes, the evidence did show he was paying for half of the kid's college education, who was up at Starkville, living 100%, and also paying $567 to the custodial mother, who the evidence did not show any of that was going to the child. So there are a lot of complicated issues to look at in reducing the age of majority. I haven't heard as many, I have heard a few chancellors say they wanted to keep it as it is, but I've also heard quite a few say that they would want to reduce it. The reasons for that, Ms. Barnes, were the same as what Judge Slogel stated, that a lot of these custodial parents are still spending quite a bit of money on their children, even those that are beyond the age of 18, through health insurance or, having to put a roof over their head because they're still living at home, et cetera, and putting food in their mouths. So that's what the concerns were that from the chancellors that I spoke with. Don't know if that's one that we can tackle fully today. We may have to come back to that. I'd love to see the past legislation that had been introduced to reduce it, to see if that's something that maybe the task force can make a recommendation on. Maybe that would be helpful.
With that, then I think what we can do is, because we actually prepared a chart, all this kind of stuff when we did it. So why don't we can send that out to the task force? Why don't we do that? We'll get that prepared and can share that.
Right.
Which may, by the way, answer some of those or narrow down some of those issues.
Very
And
good.
I'm wondering too, if we address some of these issues just from the child support perspective, if we, including even some of these age factors, that we wouldn't really need to change the age of majority, because we would get it dealt with someplace else. I don't know.
Maybe.
Okay.
Yeah. Listen, Judge McCarty apparently is a huge Alabama fan. And he wants adequate time to be able to get his work done prior to rooting on Alabama against whoever they're playing this weekend.
I feel like you're ratting me out a little
I
bit.
am. I'm ratty. I'm throwing you under the
Roll Tide, don't worry about it.
No. It's hate Alabama week on my end.
So I was going to make a recommendation, since we've been going for an hour and 50 minutes, we go ahead and adjourn. We've got other dates set that we can pick this up and take it on. Anyone opposed to adjourning?
I
Mr.
can
Chin, I think
throw
you had a
out,
motion.
can I
I was
throw
gonna
out
say,
one more thing to consider that we didn't mention, but it's something Professor Bell brought up to me before, is that we might want to make a recommendation regarding PERS, that the plan be allowed to pay out to the former spouse on a monthly benefit like that, instead of having to throw us into valuing these plans are detrimental to the employee, the PERS employee anyway. So I would think that the legislature might like that option and be kind of simple. It would be a simple thing to do. I just throw that out if we can just be thinking about that maybe for the next time.
Will you take, Judge Schlegel, will you take out a life insurance policy on myself and Representative Dr. Ham if we present that?
So I'll have to say that I know that's going to be a difficult one. The truth is, it damages the PERS employees more than it helps them, because it gets divided anyway in other ways in divorce. But I know that's not going to be people's perceptions. But that would be my number, outside of what we're already charged with. That would be my number one thing to consider. I think it makes divorce much more difficult.
Absolutely.
I know that when I was bringing that up, Judge Schlegel.
As chairman, we'll make sure that that's on the table for further discussion at a later meeting. Because I agree that PERS is an anomaly as far as retirement accounts are concerned, and has always been treated differently, and probably something that we need to look at. Okay.
Move.
Mr. Chin has moved that we adjourn.
He has to stay here because the golf is about to start. So he has to stay here and type up the minutes.
He's carrying Sergio's bag later, from what I hear. Is there a second?
Second.
Okay. Any opposition to adjourning for today? I appreciate everybody. If you oppose, please raise your hand. Seeing no hands. Thank y'all very much. We're adjourned for the day.
Thank you.
Thank
y'all.
you.